in the United States. Many people believe that if the police fail to read them, they're Miranda rights. You have the right to remain silent. The rest of the warning, the entire case automatically collapses and all charges must be dismissed. But in reality, US law works very differently, and understanding the true legal rules behind Miranda warnings is crucial for anyone facing arrest or questioning. Score. The Fifth Amendment to the US Constitution protects individuals from being compelled to incriminate themselves. Teen. And the landmark 1966 Supreme Court case Miranda v. Arizona created the requirement that police must advise a suspect of specific rights before beginning a custodial interrogation, meaning questioning, that takes place while the suspect is in police custody and not free to leave. Sue. However, Miranda rights are not required during every interaction, every arrest, or every stop. And this is where most confusion begins. Police officers can arrest you without reading you your rights, and doing so is not illegal, unconstitutional, or grounds for automatic dismissal of charges, because the requirement to read rights only applies when two specific conditions exist. You are in custody, and the police want to interrogate you to obtain statements that could be used against you. Pith. Officers arrest you but do not ask you questions. They do not have to read you anything. If they question you, but you are not legally in custody, for example, during a brief traffic stop, a street encounter, or a voluntary conversation, Miranda also does not apply. B's. This means that the absence of a Miranda warning does not invalidate an arrest. D. Does not invalidate charges and does not stop prosecutors from using physical evidence, witness statements, surveillance footage, or anything else gathered during the investigation. What Miranda actually protects is the admissibility of your own statements, and only those statements made during custodial interrogation. If the police violate Miranda by questioning you while you are in custody without giving the warning, the usual remedy is suppression, meaning your answers cannot be used against you in court. However, the charges themselves may still proceed if the government has independent evidence. Day. This is why failing to read Miranda rights almost never destroys an entire case unless the prosecution was relying heavily on the suspect's confession, and that confession becomes inadmissible. Speds. Many people are surprised to learn that even if your unworn statements are suppressed, police can often still use evidence discovered because of those statements under certain exceptions, especially when the evidence would have been found anyway. Courts also allow officers to testify about the fact of an arrest, the circumstances of the stop, and anything you voluntarily blurt out without being questioned, because spontaneous or unprompted. Statements are not considered the product of interrogation and do not require Miranda warnings. 2. Another key misunderstanding is that police are allowed to use deception, pressure, or psychological tactics during questioning as long as they do not physically threaten you. Thens, refusing to talk after being arrested is your absolute constitutional right. But many suspects unintentionally waive that right by continuing to speak after a warning is given. To invoke your rights, you must say something clear, such as "I want to remain silent" or "I want a lawyer." And once these statements are made, interrogation must stop unless you reinitiate conversation. If police ignore your request and continue questioning, anything obtained afterward is likely to be suppressed. Courts also look closely at whether a suspect was truly in custody, because being handcuffed, placed in a squad car, or taken to a station is not always necessary to meet the legal definition. Instead, the test is whether a reasonable person in that situation would feel free to leave. 2. If you were questioned in an environment that felt coercive or where officers created the impression you could not walk away, a lawyer may argue that you were effectively in custody, meaning Miranda should have applied even if the officers claim otherwise. Another major exception to Miranda involves public safety, where officers do not need to give warnings before questioning if they reasonably believe an immediate threat exists, such as a missing weapon or an imminent danger to the public. In that case, statements may still be admissible even without the warning. Importantly, even when Miranda rules are violated, prosecutors may still use your suppressed statements to challenge your credibility if you testify in court and tell a story that contradicts what you originally said. This means the statements are not admissible as proof of guilt, but they can be used to impeach you. making it risky to rely on the violation as a defense strategy without legal guidance. Courts have repeatedly emphasized that Miranda is a procedural protection, not a get-out-of-jail-free card. Its purpose is to safeguard the voluntariness of a suspect's statements, rather than to serve as a punishment for police mistakes. Physical evidence exists: drugs, weapons, stolen property, fingerprints, DNA, video footage. Victim testimonial case will likely move forward even if no warnings were given. Many defendants learn too late that even if the police failed to read them their rights, prosecutors can still convict based on independent proof. For this reason, lawyers strongly advise individuals to remain silent and ask for counsel immediately upon being detained, because continuing to speak only creates more usable statements. Mourns. A proper Miranda warning is given. Anything you say afterward becomes legally admissible. It is also important to understand that police do not have to read Miranda rights the moment they place handcuffs on you. There is no timing rule, only the requirement that the warning precede custodial interrogation. This is why officers often arrest suspects, transport them, complete paperwork, gather evidence, and only afterward decide whether interrogation is necessary, at which point they read the warning. In many cases, police deliberately choose not to interrogate at all, meaning Miranda is never triggered, so the warning is never given. The only scenario in which charges might realistically be dropped, because of a failure to read rights, is when the prosecutor's entire case depended almost exclusively on the defendant's confession and no other substantial evidence existed. And that confession becomes inadmissible due to a clear Miranda violation. Then, prosecutors may attempt to argue that the confession was voluntary or that the defendant was not in custody. And courts often resolve these disputes based on detailed factual analysis. Thoughts. Ultimately, the belief that they didn't read me my rights, sir, my charges must be dropped, is one of the most persistent myths in American criminal law. Anyone facing this situation should understand that the real question is not whether the warning was given, but whether statements were used, and whether those statements were the result of custodial interrogation. The safest and most legally protective actions for any suspect remain consistent. Remain silent. Do not answer questions without an attorney. Clearly invoke your rights, and never assume that a Miranda violation will make the entire case disappear, because in most situations, the charges will continue, the evidence will remain. The courts will focus solely on whether any statement used against you was lawfully obtained under constitutional standards.